morning, everyone. My name is Peter Leroux. I'm an executive director, an executive consultant at the Department of Employment in ENSafrica, and I've been asked to moderate the discussions in this presentation. The purpose of this pop-up webinar is to provide employer members, our clients and other people with a forum in which we can discuss important new developments, in which we can then give further guidance and generally inform us of how we should go about this important issue. If you look at as you will see from our discussions later on, you will see that the Code of Good Practice on harassment in the workplace has important consequences for our clients, and they will have to take steps, I think, to regulate employee behaviors in much more detail in the future. And from this point of view, this pop-up webinar, the second pop-up webinar that we have, will be of great importance. Our presenters are Perrine Rogers, Audrey Johnson, and ENSafrica Dube. They are all experienced attorneys. They are all directors of a firm, and they have vast experience in this regard. They will each make a short presentation, and then we will open the floor for discussion and comment. There is provision made for questions to be put onto the question and answer box, and I will read them and I will see which ones are important, and then we'll take it from there. The hope is to provide short, concise seminars or pop-up webinars in this regard, so that any topic that we touch or deal with will be for no longer than 1 hour, and that employees or members of our staff and clients can go back to their busy lives, hopefully better informed about the topic. In the spirit of this concision, I will now turn to Perrine, who will make a first presentation. Thanks. Over to you, Perrine.
Morning, Peter. Morning, everybody. It's great to be with you this morning. Given that the Code of Harassment was gazetted on the 18th of March, 2022, it's quite recent. So we thought having this seminar would be beneficial to our clients and to our employees. So I thought I would start by giving you a snapshot of what the code provides, and Audrey and ENSafrica will then deal with some of the details around the code. So I have sort of 8 points that I'd like to work through with you this morning. And I guess there's no better starting point than the effect of the code. So what the code, the new code on harassment does is that it repeals the previous 2005 amended code. It's a guide by our courts. It's a guide, but our courts will use it as an interpretive tool when considering an employer's compliance with its obligations in terms of Section 60 of the Employment Equity Act, as well as when interpreting and adjudicating disputes relating to unfair dismissals, as well as discrimination disputes. As most of you are aware, the previous code had effectively been interpreted by our courts as binding through various cases that have been traversed through the years. And our view is that an employer would need to present extraordinary circumstances to deviate from the code, albeit that it is but a guideline and a regulation that is issued in terms of the primary piece of legislation, which is the Employment Equity Act. So what the new code does is it expands on its predecessor in 2 ways. It expands on the definition of harassment. It makes some modifications to the definition of sexual harassment, and it includes a new form of harassment, racial, social, ethnic origin harassment. The objective of the code remains the same, which is to eliminate all forms of harassment in the workplace, and importantly, in any activity linked to or arising out of work. So this is a broader definition and would include work-related trips, training, social events, and as well as working virtually. So what does the code do? The code provides you as employers with guidelines to employers and employees, in fact, on the prevention and elimination of all forms of harassment as a form of unfair discrimination in the workplace. And that's quite important to think about. It's that it still must be linked to a form of unfair discrimination. So it must be linked to a listed ground or an arbitrary ground in order to qualify as harassment. What it also does is it provides important guidelines for employers on human resources, policies and practices and procedures that need to be put in place in order to deal with harassment appropriately. The code places an emphasis on privacy, equality, and the right to respect each other's dignity. And this stems primarily from the genesis of the code, which is the ILO Convention 190, and its recommendations concerning the elimination of violence and harassment in the workplace. South Africa is a ratifying state to this convention, and as such, it needs to interpret and adopt an inclusive and agenda-inclusive response to the prevention and elimination of harassment in the world of work. So we give effect to that, us being bound by the ILO Convention through various statutes, with the Employment Equity Act being the primary statute, and this piece of this code, which is a regulation which has been issued in terms of the Employment Equity Act. The application of the code is fairly wide, similar to its predecessor, so it applies to all employers and all employees, and employees includes applicants for employment as defined in the Employment Equity Act. The code specifically directs that if one is looking at whether a person is an employee or not, one must have regard to the presumption of employment in terms of Section 200 of the Labor Relations Act. Interestingly enough, volunteers are also considered to be employees. The code would then apply to contractors, suppliers, persons in training, clients, customers, and people who have dealings with the business of the employer. And it's couched particularly wide to give effect to the ILO Convention and to give effect to a broad range of protection, to provide protection to employees and to individuals that would traditionally not form part of the protection. And yes, customers, I see there's a question there, it would apply to customers too. In terms of the definitions and how one views harassment, the code is broad in that nature too. So it significantly expands on its predecessors in terms of dealing with harassment, particularly the definition of harassment. And I know that Audrey will be dealing with that in quite some detail. And I think that has caused some consternation. We've seen quite a lot of press articles about passive-aggressive harassment, eye-rolling, etc. And I think it's quite an interesting debate, and hopefully we'll get to unpack that with you as we move along in the presentation. And lastly, and quite interestingly enough, the code identifies that there are other statutes that would impact on harassment. So the code mentions the Harassment Act, as well as the Promotion of Equality and Prevention of Unfair Discrimination Act, more commonly known as PEPUDA. So these are examples of other pieces of legislation that will impact on dealing with harassment. So it's not just limited to the Employment Equity Act and an employer's obligations in terms thereof. There's a broader and wider scope in terms of which harassment needs to be considered and assessed. So PEPUDA in particular applies to harassment that does not arise from an employment policy or practice, but rather to harassment that takes place as a result of the conduct of a client, an independent contractor, a customer, a member of the public, an employee potentially of a different business, as well as acts that are generally outside of the control of the employer, but still within the broader scope of the world of work. So for example, when an employee is commuting to and from work. It also applies where the victim of the harassment is a customer or another member of the public and complains that the perpetrator is in fact an employee of the employer. So I think that's quite important for us to understand that there's an interlinking between various acts and that employers would need to look at it holistically when considering harassment in the workplace. Peter?
What I find interesting is this division between the PEPUDA and the Employment Equity Act and how that will apply in practice. But we'll discuss that later. Audrey, you've got some comments to make. Over to you.
Yes, thank you, Peter. Morning, everyone. Thanks for joining us. So I think what I really just want to focus on is, as Perrine has mentioned, I think that the primary impact of this code is that it goes into quite a lot of detail in terms of what the definition of harassment is and different types of harassment. And then I'm also going to touch briefly on how the code changes the situation in relation to sexual harassment. But as a starting point, this code is the first time that we have something that tries to define harassment, because harassment isn't defined in the Employment Equity Act. The Employment Equity Act simply says in section 6.3 that harassment of an employee on one of the grounds listed in section 6.1 of the Employment Equity Act is a form of discrimination, but it doesn't define what harassment is. So this code attempts to do that. And what it says is that it's generally understood to be unwanted conduct which impairs dignity, and it creates a hostile or intimidating work environment, or is calculated to or has the effect of inducing submission by actual or threatened adverse consequences. And finally, it must be related to one of the listed grounds in section 6.1 of the Employment Equity Act, which is something that Perrine has mentioned as well. It's something that's in section 6.3 of the Employment Equity Act, and I'm going to deal with that in a bit more detail just now. But if we just look at this definition, the focus very much is on two elements. One is that it must be unwanted. So that's what distinguishes harassment from acceptable conduct. The complainant must be able to show that this was unwanted. The code then goes on to say that when looking at whether or not you can say that conduct is unwanted, there's two issues that really arise. The one is, did the perpetrator know that the conduct was unwanted? I.e., was it communicated by the victim, either verbally or non-verbally through their body language, or directly or indirectly? Or alternatively, if the perpetrator didn't know that it was unwanted, should they have known that it was unwanted? And in that regard, the code says that the inquiry there is the conduct of such a nature that the perpetrator knew or should have known that it is generally considered to be unacceptable. So that really is the key issue. Is this conduct which is unwanted, either because the perpetrator knew or should have known that it's unwanted? And arising from all of this, one of the key issues that I think our courts are going to grapple with the most is whether or not the test is subjective or objective. And the code is confusing in this regard because it makes a number of statements and comments that it's not very clear. It doesn't clearly state the test is objective or the test is subjective. And it makes a number of comments that suggests that there is very much a subjective element, in that it is very much based on the impact on the employee and the perception of the employee. So if we just go through that, what the code says is that whether or not conduct constitutes harassment should be assessed on an objective basis, but from the perspective of the employee that alleges harassment. So the employee's perspective comes into it, which means there is a subjective element. And then it goes on to say, although it has just said that it must be assessed on an objective basis, it then goes on to say the primary focus of the inquiry is on the impact on the employee. So again, that suggests that it's something more subjective. What is the impact on this particular individual employee? And when you look at the perspective of this individual employee, is it unwanted? But then the code then goes on to say that it must be accepted that in some circumstances, the perceptions of the person harassed are not consistent with the views of a reasonable person. So again, more objective in the situation of the complainant. And a person charged with harassment may seek to establish that the victim's perceptions are not consistent with societal values reflective of our constitutional ethos. So what do we make of this? It's like a complete mix-up of subjective and objective in this test. And I think this is one of the things that our courts will have to grapple with the most when faced with claims of harassment, is, are we viewing this purely subjectively from the perspective of the employee and from the impact of the conduct on this particular victim in this particular situation? Or do we lean more towards applying an objective test where you've got to view all of this reasonably? And I would suggest that it has to be, the subjective part is important. You do have to look at the impact on the victim to determine whether or not conduct amounts to harassment, but it must certainly be tempered with an element of objectivity. And the courts will inevitably look at whether or not the victim is being reasonable. And I think the fact that the test specifically says, when it deals with whether or not the conduct is unwanted, it specifically looks at whether or not the perpetrator should have known that the conduct is unwanted, is a clear indication that that must be an objective test, because it can't possibly be said that you should have known that conduct was unwanted if it's purely subjective and if there isn't an element of reasonableness. So I think our courts would probably land on saying it's a more objective, or following a more objective approach, but certainly always still having regard to the impact and the perceptions of the victim. So I think that's probably going to be one of the greatest areas of confusion arising from this code. And while the code is very well intended insofar as it focuses on the impact on the victim and the perception of the victim, I think what it is going to do for employers, unfortunately, is that it's going to open the floodgates to complaints of harassment, because I think employers will increasingly see complaints by complainants who have a subjective perception that they have been wronged. And that may not necessarily be objective. It may be opportunistic. It may be retaliatory. It may be employees that are facing complaints against themselves, either misconduct or poor work performance issues, and where those are being tackled and they then perceive that as being harassment. And that may well result in employers having an increasing number of complaints that are based purely on a subjective perception. So unfortunately, I think this is going to create a lot of work for employers in terms of processing those sort of complaints. But it's important then to also, just further to that, I think what aggravates that problem then as well is the extensive list of the types of harassment that is then in the code. So what the code then tries to do is it provides a very broad and wide-ranging list of types of conduct that could constitute harassment. And again, I think this is probably well-intended and is probably meant to assist employers and employees in having knowledge and an understanding of what could constitute harassment. I think the negative effect of this is that employees may well adopt a tick box approach. And employees who don't fully understand the test for harassment and who are lay people and don't understand all the legal nuances may well just run to this list and try and identify something on the list that they have experienced and lodge a complaint of harassment because it's something that's on the list, without fully appreciating that it can only be harassment if you can show that it was unwanted because the perpetrator should have known that it was unwanted. And as we've mentioned previously, if you can show that it is related to one of the grounds for harassment. So it's not as easy as just saying, I experienced this thing and it's on the list and therefore it's harassment. But of course, the employees aren't going to know that. And again, I think the danger with this very extensive list in the code is that it's going to open the floodgates to these sort of complaints. Perrine, I see Perrine just wants to come in there and make a comment.
Thanks, Audrey. So I wanted to just, chat to you about what you thought about whether having such an extensive and long list potentially does a disservice to what the intention of the code is, because I think we're all at idem that addressing these issues in the workplace is extremely important. I mean, we've seen a high rise just in our practices on an everyday basis in dealing with sexual harassment complaints, as well as workplace bullying, cyberbullying, online bullying. These things have really come to the fore during the COVID-19 pandemic. And I just wanted to, I think it's an interesting debate whether making setting out this sort of shopping list of itemized issues that could fall within harassment really sort of may, in fact, inadvertently do a disservice to what the intention of the code is. I just wanted to, put that out there as a thought.
Yeah, no, Perrine, I think that's exactly spot on. And I think that, like I said, it may have been well intended, but I think that it does do a disservice to the intention and the purpose of the code, because it's just too broad and too wide ranging, so that it almost becomes meaningless. If the code had been much clearer on the definition and the test for harassment and left it at that, without all these examples, I think that would have been far more helpful. That's my personal view. So just in terms of some of the examples, just to give you some of the flavor of it and why we're saying that it's so wide ranging, there is a very long list and you can all go and have a look at it, but just some of the examples It includes things like slandering and maligning an employee, conduct which humiliates, insults, or demeans an employee. Here's an example of one that's very wide. Withholding information or providing incorrect information is something that they say could constitute harassment. Sabotaging or impeding work performance, ostracizing, boycotting, or excluding an employee. So again, very wide in terms of excluding employees. Intolerance of psychological, medical, disability, or personal circumstances. Pressurizing an employee to resign. And then I think probably the most controversial one, and the one that has been in the media and that you've all probably seen and heard about, is this wide concept of passive, aggressive, or covert harassment. And I'm just going to read to you what that all encompasses, because it's exceptionally broad. It says it may include negative gossip, negative joking at someone else's expense, sarcasm, condescending eye contact, facial expressions, gestures, mimicking to ridicule, deliberately causing embarrassment and insecurity, invisible treatment, I'm not sure what that means, marginalization, social exclusion, professional isolation, and then deliberately sabotaging someone's dignity, well-being, happiness, success, and career performance. I mean, that is very, very wide. And like I said, the problem is going to be that your ordinary employee is not going to understand that to prove harassment in this form, you still have to show that the perpetrator behaved in that manner because they were harassing you on a listed ground. And that it's not as easy as just saying, well, you rolled your eyes at me, so therefore you harassed me. Employers are inevitably going to be faced with those sort of complaints, and it's going to be a challenge to process them because they don't necessarily all fall within the meaning and definition of harassment properly applied. So we've emphasized a lot the fact that it must still relate to one of the grounds of harassment in terms of, grounds of discrimination in terms of the Employment Equity Act. And I just want to deal with that in a bit more detail. You'll all know that in Section 6.1 of the Employment Equity Act, there is a list of grounds of discrimination, and it includes things like race and gender and sexual orientation and belief and ethnic origin and religion and all of those things. And then at the end of that list, it says, or any other arbitrary ground. And the approach of our law is that if an employee alleges unfair discrimination on a listed ground, then that is unfair discrimination. And the onus is then on the employer or the person who's alleged to have committed the unfair discrimination to prove that the harassment did not occur. So either that the incident never took place or that it doesn't fall within the definition of harassment. But then there's also this concept of an arbitrary ground. And an arbitrary ground is generally considered to be any ground that impairs the fundamental human dignity of a person or has the ability to affect them adversely in a comparably serious manner. So if an employee is saying that you harassed me when you rolled your eyes at me, they have to be able to show that it was because of one of the listed grounds. So you rolled your eyes at me because I'm pregnant, for example, in its simplest terms. That's why you're rolling your eyes at me, and that's why you're being condescending, and that's why you're being negative towards me, or why you're excluding me. It's because I'm pregnant. Alternatively, if they don't rely on a listed ground like pregnancy, they have to say, you are doing this to me based on some other ground, which is an arbitrary ground, and it is a ground which impairs my dignity as a human being. And I think that that's probably going to be the biggest challenge for employees that make these sort of complaints, is that they have to bring it within one of the listed grounds in terms of the Employment Equity Act. So I think that really is all I wanted to say on the issue of harassment before I move on to sexual harassment. I don't know if anyone's got any comments or if anyone wants to jump in for a debate or discussion here before we move on to look at sexual harassment.
Audrey, there is one interesting comment that talks about invisible treatment not making an employee feel included within the team or the workplace. That to me is an interesting ground, and I think it's an important point, because in our multicultural society, perhaps that is going to be one of the more important issues, making certain that somebody that comes into the workplace is actively encouraged to be part and participate in the team. Otherwise, that type of claim is going to arise.
I think that's right. That probably is what invisible treatment refers to. There is specific reference, though, as well to exclusionary conduct, social exclusion, marginalization. All of those things are specifically referred to. So I think that is probably what it's intended to address. Perrine?
Perrine, yeah?
Yes, so I wanted to add to that, what you were saying, Peter. I think that what's going to be quite important is a sort of a drive to sensitize the workforce to what the code says, and how we need to, you know, embed it in what we do as employers in terms of policies and procedures. And I mean, you make a good point. When a person joins a team, you know, how do we onboard people? Because of the wide nature of the code, there's going to have to be a similarly wide response, I think, in terms of sensitizing the workforce as a whole to what, and that the best way to do that is probably through extensive training.
I agree. There's an interesting question, and we might as well deal with it now while we're talking. The list of examples of harassment, Perrine, is that derived from the ILO convention itself, or is this a sort of extension of what the ILO convention says?
Yeah, I think it's probably a bit of both. I think because the question related to whether it comes from our legislature or I think it derives mainly from the ILO convention, because that convention is quite broad in its nature. And they've leaned heavily, the drafters of this code, on the convention. But you will note that in the code itself, specific reference is made to South African case law. So a lot of the cases that we're all familiar with, Campbell Scientific, Rustenburg Platts, McGregor, they're all in there. And it's a codification of, I guess, the convention as well as the South African case law, and particularly in relation to sexual harassment, where we have a huge body of case law. The code seems to draw quite heavily from there.
An interesting comment coming through now from a participant is, for example, comments made about weight or height, or do you think that could be a field that is that going to be impactable? Well, that, you know, could that be regarded as some form of harassment?
I definitely think it could, Puck. I think, you know, those sort of comments would fall under negative joking, negative gossip, all of those sort of things. And I think that's probably a good example of something that could be an arbitrary ground within the meaning of Section 6.1, because it's not, you know, there's nothing in the list of grounds that refers to someone's weight, but it is the ground on which you are making those sort of jokes is based on a person's physical appearance, which certainly is something that impairs their fundamental human dignity. So that's a very good example of an arbitrary ground, and where it certainly could be harassment if you are joking or making inappropriate comments about someone's weight or appearance. I also just see there, Jan. Hi, Jan. Nice to see you. You've joined us. Jan's made a good comment where he has asked, could generally being unwanted arise from something that could have been communicated by presentations by the employer on harassment? So I think the point Jan is trying to make is spot on, and it goes back to what Perrine was saying about the training. So when it comes to trying to prove that someone ought to have known that this sort of conduct is unwanted and unacceptable, employer communication and training is going to be critical, and the employer is going to be much better placed to show that you should have known that something was unwanted if there has been presentations or training on that, you know, that sort of conduct that is unacceptable. I think that's what you meant, Jan. So I hope that addresses your comment. I think that's spot on. Okay, so then if we, I don't want to cut into Sipamandla's time because he's also dealing with a crucial aspect of the code. So if we just briefly look at the issue of sexual harassment, what the code does, importantly, it repeals the previous code of good practice on sexual harassment, the 2005 code. So that no longer applies. And then it slightly changes the definition of sexual harassment. So in the old code, sexual harassment was unwanted conduct that violates the rights of an employee and constitutes a barrier to equity in the workplace. It was quite a straightforward, simple definition. This contains a more extensive definition in that it says it's unwelcome conduct of a sexual nature, whether direct or indirect, that the perpetrator knows or ought to know is not welcome. So again, there's that objective element that the perpetrator ought to have known that it wasn't welcome. But then it goes on in this definition to make, again, several comments that suggest that it could be quite subjective, because it says sexual harassment may be offensive to the complainant. and it may make the complainant feel uncomfortable, or cause harm or inspire the reasonable belief that the complainant may be harmed. So for me, those two aspects of it may be offensive to the complainant and it may make the complainant feel uncomfortable is again quite subjective, and looks very much at the perceptions of the complainant. And then finally, it says that it must violate the rights of an employee and constitute a barrier to equality in the workplace. And that's similar to the old definition. So it's not that different, but there are elements that are slightly different. And then in terms of the procedure for processing sexual harassment complaints, I just wanted to make the point that it's actually not that dissimilar to what was under the previous Code of Good Practice on the handling of sexual harassment cases. So I don't think employers will have to do too much work there, but the real focus for employers is going to have to be on expanding their policies and their procedures to deal with the more general aspect of harassment as well. And I think then it's over to Sipamantla to deal with the third and new form of harassment that the code touches on.
Thank you, Audrey. Morning, everyone. As my colleagues Audrey and Parin have indicated, the previous code addressed the issues relating to sexual harassment, but then with this new code, the legislature or the minister has also added ethnic, racial, or social origin harassment as specific forms of harassment to be dealt with in a code of good practice. As you know, racial, ethnic, or social origin harassment is a form of unfair discrimination prohibited by Section 6(1) of the Employment Equity Act. Now, the question is, what is racial harassment? The code defines racial harassment as unwanted conduct which can be persistent or a single incident that is harmful, demeaning, humiliating, or creates a hostile working environment. Racial harassment occurs where a person is subjected to physical, verbal, or non-verbal conduct or other conduct based on race, which undermines their dignity. And I think it's important to highlight at this stage that similar to the cases that our courts have dealt with relating to sexual harassment, they have confirmed that a single act of sexual harassment may constitute ground for dismissal and may be enough to confirm that it's sexual harassment. The same then applies to how they have created or how the code deals with racial harassment. The point is made that a single incident of racial harassment can be harassment. And when it comes to dealing with harassment, this includes issues such as racist, verbal, and non-verbal conduct, remarks, abusive language, racist name calling, offensive behavior, gestures, and racist cartoons or memes. I will deal with this later on in more details when I address the various forms of racial harassment. But what is important to note or to take into account is that with this new code having come into effect, it's important that employers go back and train employees or caution employees to be aware that the new code also highlights the issues relating to racial, ethnic, or social origin. Because you may find that there were employees who were known in the workplace as people who generally joke or they share memes or share cartoons on the workplace WhatsApp group or any platform. Those things, if you share such things on platforms or you send emails where you are sharing memes which are racist in nature, that can form part of racial harassment, and the employer may have to take action to deal with such conduct. Now, another important thing to take into account is that in terms of this code, it is specifically mentioned that conduct involving racial innuendos or stereotyping or other types of racial conduct is assumed to be offensive and unwanted. Audrey earlier on dealt with how is conduct supposed to be understood, or how do you know that the conduct is unwanted? Yes, you may know that through the complainant indicating that the conduct is unwelcome, or you may be required to know that such conduct is unwelcome. So the code does make it clear that the conduct involving racial innuendo, stereotyping, or other racial conduct is assumed to be offensive and unwelcome. So perpetrators or any other employees in the workplace, they should take note that such conduct is unwelcome. You don't need to wait for someone or the complainant to tell you that such particular racial conduct is unwelcomed. Now, I'd like to move on then and deal with the various forms of racial harassment as stated in the code. The first one is abusive language and racist jokes, cartoons, or memes, including communication that amounts to hate speech. The example I can give there, it's like calling someone a kafir. We've had cases, Audrey indicated earlier on that the code draws much of its content from the ILO convention, but also from our case law. We've had cases where the Constitutional Court has had to deal with the issue where a fellow employee called another a kafir in the workplace. And that's a judgment of SARS versus Kruger, amongst others. And in that judgment, the Constitutional Court did make the point that it's important when dealing with these issues to take into account the history of South Africa, the past of apartheid, and that calling a fellow employee a kafir is the worst kind of racism in the workplace. And before I move on, perhaps before anyone asks why I'm using the word in full kafir, I'm using it in full because in the very same judgment of SARS versus Kruger, Chief Justice Mogoeng warned that it's important to use the word as it is instead of the neutralizing reference saying it's a K word, because this word was meant to be the worst form of verbal abuse by a fellow employee to another in the workplace. So such conduct can never be tolerated. Such abusive language is something that cannot be tolerated. And the code now has come in to codify what our courts have said in this regard. The second form of racial harassment that is dealt with in the code is racially offensive written or virtual material, including online communication. In this day and age where most people are using social media platforms, it's important to take into account that where an employee posts racially offensive material on social media, such an employee may be taken into task by the employer. The example there, it's one judgment that was dealt with by the Labour Court of Edcon versus Contralesa, where the employee posted on Facebook about the reshuffling that former President Zuma had made, and then the employee then used the racial monkey slur in her Facebook post. Some of the employees then, friends or people who became aware of the post, they wrote to Edcon complaining that how is Edcon tolerating or condoning such behavior from its employees. And importantly, from that employee perspective, in her Facebook page, she had indicated that she's working for Edcon, and that's how then the employees the members of the public could link this to Edcon, that this person works for Edcon. In that case, again, it was found that even though the employee was posting on her private social media account, but still the employee was posting racially offensive material, and that had an impact on the employer because the employee could also be linked to the employer. And as such, the dismissal of an employee for making such racially offensive remarks or material on social media was found to be fair. The third form of harassment that is dealt with in the code is the one of racist name calling or negative stereotyping in impacting on a person's dignity. For instance, it may be considered to be negative stereotyping to refer, to Black employees who occupy senior or executive positions as BE appointments. That is kind of stereotyping, that because you assume or you make that comment that this is a BE appointment because you think the person is there because as a reason of his color or race, instead of that particular individual being competent and suitable to occupy that particular position. So employees need to be aware that using such negative stereotyping or racist name calling is something that forms part of racial harassment and is prohibited in terms of the Employment Equity Act. Other forms of racial harassment include offensive behavior in the form of open hostility to persons of the specific racial or ethnic group. It also includes subtle or blatant exclusion from workplace interaction and activities and other forms of marginalization in the workplace. And the last point or last form that is mentioned in the code is threatening behavior, which intimidates a person or creates a hostile work environment. It's important to mention that while the code lists 6 forms of racial harassment, this is not a closed list. It may happen that you commit or you say something that forms part of racial harassment, even though it's not mentioned or is specified in the code. And in such circumstances, the employer then will still have to deal with such a conduct in the workplace. Now, the last point I want to touch on is the test then that needs to be applied when you deal with a racial harassment in the workplace. The starting point is to understand that to establish harassment based on race or ethnic or social origin, it has to be established on a balance of probabilities that the conduct complained of was related to race, ethnic, or social origin. The test then that needs to be applied is an objective test with reference to a normal or reasonable person. So as Audrey indicated, that when you deal with sexual harassment, there's some kind of confusion where the test is subjective or is objective. When it comes to racial harassment, the code is also clear that it's an objective test based on how a normal or reasonable person will consider such conduct. But importantly, the codes also make a point that another factor to take into account will be how the alleged perpetrator treats people or persons not of the complainant's racial group or ethnic or social origin. So this will require the employer to assess how the individual behaves towards employees of another race compared to those of his or her own kind. And finally, the last point to make is that when it comes to racist language, this issue has also been decided or determined by the Constitutional Court in the judgment of Rustenburg Platinum Mines versus Bester, where the court confirmed that the test to apply in determining whether the individual has used racist language is whether a reasonable, objective, and informed person would, on the correct facts, perceive such conduct to be racist or derogatory. Thank you, Park. I'm not sure if you have any other comments or questions.
What I find interesting is that if you look at the things we've been dealt with, employers will have to almost control employee behavior in a more far-reaching manner than ever before. Typically, you're dealing with a wider range of issues now that can cause an employer detriment, and the employer is going to have to change all sorts of things to try and manage employee behavior. And I think that's a topic that Perrine also will be dealing with now. Perrine, over to you.
Thanks, Siphamandla. Thank you, Peter. So I thought before we get to the Q&A, I will just wrap up. What are the key learnings that we can take away from the code, albeit that it's literally hot off the press and we're all trying to digest all the very many definitions and categorizations of harassment, sexual harassment, and racial, social, and ethnic origin harassment. I think the starting point is to understand that employers have an obligation in terms of Section 60 of the Employment Equity Act to take proactive and remedial steps to prevent all forms of harassment in the workplace. And importantly in the code, this includes an assessment of the risk of harassment that employees are exposed to while performing their duties as far as reasonably possible. I think that's quite an interesting observation to take away from the new code. You must have a zero tolerance attitude towards harassment. The code says that explicitly. And you must create an environment and a workplace that respects the dignity of all employees. So what do you need to do moving forward? I think that at the core of what we've discussed thus far is that you're going to have to relook at your policies. Generally, most employers have a sexual harassment policy. So that needs to change because the policy is wider than that. The code rather is wider than that. And it must include harassment, sexual harassment, and harassment based on racial, social, ethnic origin. And it must align with the new code. The code itself says that the policies that you adopt should be guided by the code. It must then be communicated to all employees. And in terms of the content of the code, paragraph 9.4 of the code specifies what at a minimum the code must, your harassment code and policy in the workplace must contain. And I think, as I said at the beginning, the previous code, our courts literally did interpret it as binding, albeit that it was simply a guide. If you look at all the cases on sexual harassment, every single case referred to whether there was compliance with the 2005 code. So I think we unless there's a court pronouncement to, the contrary, I think that we'll have to interpret this code in the same way. And then in addition to relooking and redrafting the policies, training. I think training on the code is going to be critical, and how you roll that out in the organization. I think it's going to have to be a comprehensive training from shop floor steward individuals all the way to your exco. I think everybody in the organization needs to understand the seriousness of what harassment deals with and the breadth and scope of harassment in terms of the new code. Importantly, a court will, the code states that in determining whether you've discharged your obligations in terms of Section 60 of the Employment Equity Act, the adoption of a policy and communicating it to employees is something that the court will look at. And as we talked about, just raising the levels of awareness in the organization. So you could have training to deal with the sort of nitty-gritty of the code, but I think that what we need to do as well is to just raise levels of awareness overall about harassment in general. The code sets out the procedures when dealing with harassment, very similar to dealing with sexual harassment. Once it's been reported, you must investigate it, must consult all necessary parties and take steps to address the complaint and to eliminate the conduct in the workplace. Failure to do so will render the employer vicariously liable. So, what are the actual steps? That remains the same. Advise the complainant of informal and formal steps that can be taken to deal with harassment. Offer advice and counseling and assistance where this is reasonably practicable. And follow the provisions of the code in a procedurally and a substantively fair manner. Something interesting that's come out of the new code is that you as employers must designate a person that falls outside of line management to assist a complainant in respect of advice or counseling. So the code states that this person can be employed by you, or interestingly enough, it can be a trade union representative, a co-employee, or a professional person such as a psychologist or a psychiatrist. Naturally, all complaints of harassment must be dealt with confidentially and sensitively. That's stated in paragraph 11 of the code. We've all known that the sexual harassment code provided that an employer may provide additional sick leave if an employee exhausts their allocation of sick leave. What the code does now is it adds its added on benefit. So if the harassment results in the employee being sick for longer than 2 weeks, the employee then can claim illness benefits from the unemployment insurance fund. So that's something that is different. And I think just as a closing remark before we start the Q&A, Peter, that I think, to go back to what Sipamandla and Audrey have traversed, these tests that are objective or objective with the subjective lens or subjective with the objective lens, that is something that our courts are really going to have to grapple with. And we're only going to really see some daylight there once we've had an application of this code through a CCMA process and ultimately up to the Labour Court. And I think that is probably where an app, ending to us doing all the talking, and maybe we can now start with the Q&A, Peter.
Thank you, Perrine. I've just been reading through the comments made, some of which you have answered the questions already. But to me, there are one or two comments that I think are very interesting. The one is from Madeleine Loyson. The idea, and it deals with this situation of when you're dealing with an arbitrary ground, it must be something that impinges on the dignity of the person concerned. And she makes an interesting distinction between a mere insult and something that goes against your very being, who you are as an individual. And then she says a comment or harassment on the grounds of obesity would qualify as harassment, but not commenting on red nail polish. I actually think it's quite a nice distinction between mere insult is not enough. It must go to the extra beam. Have you any comments on those, or do you agree with that?
Yeah, I agree completely with Madeleine and with your assessment, Pak. I think it's that's critical because the code takes its contents from the ILO convention, which gives primacy to an individual's dignity, privacy, as well as equality. I think that could be a way in which we can, even though the code is so wide, that when interpreting it, as employers, as a first port of call, and probably later as courts, that it must impugn on the dignity of an individual. And I agree totally. Mere insult is not going to cut it, albeit that the definition is extremely wide. I don't know if Sipa Mandla or Audrey has anything else to add there.
I just wanted to add that it goes back to the test for, it always has to go back to the test for discrimination in terms of the Employment Equity Act and essentially Harkson versus Lane, where to prove discrimination on a ground that's not listed, you've got to show that it's based on a ground that impairs your fundamental human dignity. And I think that's exactly where Madeleine's right. It can't just be something minor. It's got to go to something that actually impairs your fundamental human dignity or affects you in a comparably serious manner. So it's got to be serious. It can't just be a mere insult, and it's got to go to your very being and affect your dignity. And I think that's straight from the test for discrimination in terms of Harkson versus Lane. Just interestingly on that as well, sorry if I can just deal with this point while we're on it. Shivani's also made the comment about whether or not you could potentially take action against someone for something that you don't term harassment, and then you don't have to link it to a ground. You don't have to link it to a listed ground or an arbitrary ground as an employer. And I think that is something that could be possible if you charge an employee with the allegation of misconduct that you bring against the employee isn't harassment, but is unacceptable conduct, for example. You would have to show that the employee should have known that that was unacceptable and that it goes against the values of the company. So I think that is also a possibility to bear in mind, where you potentially want to take disciplinary action against an employee for something, but you can't show that it was on a ground, and you can't really prove that it's harassment, but it's still unacceptable and it's still contrary to the values and ethos of the organization. That's quite interesting as well.
Would you put that as in a disciplinary charge sheet as an alternative, or how would you formulate it? Guilty of selection harassment?
Think that if you can't prove harassment, then you would have to, the allegation that you bring against them would have to just be unacceptable conduct. Okay.
The other question that's come up is, can an employer be held liable for the actions of an employee? And Perrine makes the point, yes, that's the case. Section 60 of the EEA does make a liability, position for liability in that situation. But to me, what about delictual liability? Is it possible that this code could play a role in assessing whether an employer is delictually liable for the acts of a manager or a supervisor or something like that?
Yeah, I think, Peter, you'd still have to prove the elements of delict. So you still have to prove wrongfulness, damages, etc. I mean, I don't think that you'd be able to just say, well, there's potentially a breach of the code and that gives rise to a delictual claim. But certainly, I mean, we've seen multiple claims being brought from an employment equity perspective We have the different cases have been brought to different courts in different forums. So I'm sure that that it would be possible, but we still need to meet the test for delictual claim in the first instance.
And also, if I can just add to what Perrine has said on that test, I think what's important to bear in mind is that when you're looking at Section 60 of the Employment Equity Act, it says that the employer will be held liable for the conduct of its employees in committing the harassment if it failed to take all reasonably practical steps to ensure that it did not occur. But if you're dealing with a delictual claim, you've got to also prove the elements of a vicarious liability. So you've got to prove that it was in the course and scope of employment that this harassment occurred. So the test is slightly different, and what you'd have to prove for the employer to be held liable under a delict is slightly different.
And I suppose it would be in the High Court rather than in the Labour Court for a delictual claim, which is an interesting dynamic. If now going back to the High Court, which is a completely different ethos there to the Labour Court. And I found it interesting to see how the courts deal with that. The comment is also made, I think you made it, Perrine, that in effect, there's been academic literature which says the wide definition of discrimination on the various grounds in terms of the EA actually trivializes the importance of discrimination in the workplace. It makes it trivial almost because it covers such a wide area. Is that what you meant when you talked when you made your comment as well earlier on this issue?
Yeah, I just thought that it was an interesting, question to throw up there because it's clearly very serious issues that we're dealing with. We've, as I said earlier, we've seen a marked increase in sexual harassment and harassment claims and racial harassment and online bullying, etc. I mean, so I thought that, we understand what the intention of the code is, but does it not almost trivialize it if we've now sort of codified everything, and sort of does a disservice to the actual point of the code. I think that it's an interesting debate. I haven't really made up my mind either way, but I think it's particularly interesting. And I think it's important from a South African context that we've codified racial and social and ethnic origin harassment. I think it's the cases that Sipa Mandla went through are extremely important. And I think that it's also important, and maybe Sipa, you have a view on this, in relation to the fact that there's a presumption that the conduct is unwanted is quite important. And I think it actually indicates where, the thinking in terms of the code and the seriousness with which the drafters view that type of conduct.
Yeah, thank you, Perrine. Yeah, it's an interesting addition to say the conduct is assumed to be unwelcome, because we have had cases where someone will use like racial terms to say I was describing, like I was using as a descriptor, and the court have said, well, even though your defense is that you were using it as a descriptor, but there are other means you could have described a fellow employee or a particular individual without necessarily referring on the racial lines. So it just makes that point important. Say whenever you want to like use racial terms or you want to describe someone in a racial manner, you just need to be careful that you don't then end up committing misconduct, because you need to always assume that anything that's along the racial lines is assumed to be unwelcome and offensive.
I see our time's running up, and one comment that I found interesting is that what about domestic servants? Are they covered by this act? And if so, do they present special challenges? Perrine, Sipa?
Yeah, I think there would be, Pak. I mean, it's the definition of employee is extremely wide for a reason. It becomes it's obviously naturally difficult when you have to deal with a domestic or a worker that works in your environment. But I think you have to still deal with it properly, fairly. And in terms of what the code provides, albeit you would have to, adapt your procedure and to cater for the situation at hand. But I can't foresee why they would be excluded, if I can put it that way.
Yeah, I agree with you. I see it is 12:01, and many of the questions in the chat box have actually been answered by the participants themselves. And I must say, I found that interaction there very, very interesting and I think important. And you can look at them yourselves, I suppose. But I think we're just over over an hour into our presentations, and I'd like to close off by saying thank you very much for the participation of the audience. We hope you enjoyed it, and hopefully we'll see you at a further pop-up webinar in the future. Thank you very much for everybody.